indivisible, with liberty and justice for all.
For those of you who are here with us tonight, in case of an emergency evacuation, please exit through the rear doors of this room to one of the staircases across the hall and continue downstairs and out through the main entrance. Please do not attempt to use the elevators during an emergency evacuation. In case of a medical emergency, the automated external defibrillator and first aid kit are both located in the hallway on this floor opposite the elevator. Restrooms are located across the hall. We will be starting this meeting with the public hearings. We have applicants and members of the public here with us live and also standing by via Zoom webinar, which is being moderated by CTV. Please silence your cell phones and refrain from speaking to one another in the boardroom as it interferes with the recording. Tonight, we also have Board Member Helen Burgess participating remotely and Board Member Keith Tuttle absent. CTV will mute the speakers on Zoom until it is their time to give testimony before the board. Please be patient. If you find that you are having difficulties accessing the hearings, please visit the Town Clerk's meeting portal and click on the instructions link. A reminder that applicants, agents, and members of the public speaking, other than attorneys, will be sworn in, will state their address for the record, and will offer their testimony as it relates to the application before the board. We have very few application items that are being adjourned tonight on the agenda, so we ask members of the public who speak to keep their comments limited to 3 minutes. Unless otherwise stated at the end of each hearing, all of these applications will remain open for written comments for all purposes until a date to be announced after the hearing. Those comments can be addressed to the Board Secretary, Candace, and sent via email, mail, and/or dropped off at Town Hall. With that, I'd ask for a motion to approve the minutes of our last meeting.
So moved.
Second.
Mr. Daly.
Aye.
Ms. Kern.
Aye.
Let me see. Ms. Burgess.
Aye.
Mr. Macedonio.
Aye.
Chair votes aye. Minutes are approved. And now we're next going to go to adjournments.
Okay, our adjournments are on the decision calendar tonight. Actually, the first one is not an adjournment. I'd like to make a motion to reopen Cloverleaf Realty, Inc. to accept written submissions.
Second.
Ms. Kern.
Aye.
Mr. Macedonio.
Aye.
Mr. Daly.
Aye.
Ms. Burgess.
Aye.
Chair votes aye. Reopened.
And then I would like to make a motion to close for a decision this evening later.
Second.
All in favor?
Aye.
Any opposed?
With regard to the decision of East Quogue Realty, 535 Realty, Inc., I would make a motion to adjourn this decision to October 20th.
Second.
All in favor?
Aye.
Aye. Opposed?
With regard to decision 40 Ocean View Drive LLC, I'd like to make a motion to reopen to accept written submissions.
Second.
Ms. Kern.
Aye.
Mr. Daly.
Aye.
Ms. Burgess.
Aye.
Mr. Macedonio.
Aye.
Chair votes aye. Reopened.
And now I'd like to make a decision to close for a decision, like a motion to close for the decision tonight.
Second.
All in favor?
Aye.
Aye.
Opposed?
With regard to the decision of Scott Schlachter, I'd like to make a motion to adjourn this decision to September 1st.
Second.
All in favor?
Aye.
Aye.
Opposed?
And an announcement, Adios Holdings LLC has been withdrawn. So I guess we go back to our regular calendar now?
We do.
Okay, so on new applications, number one is SGM Excavating LLC, tax map number 900-129-2-19.2, located at 110 North McGee Street. Applicant requests relief from Town Code Section 330-11 Residential Districts Table of Dimensional Regulations for an accessory front yard setback of 22.9 feet, where 70 feet is required to legalize an accessory office trailer constructed on the premises without the benefit of building permit, and accessory front yard setbacks of plus or minus 10 feet for each of the bulk gravel storage areas respectively, and any other relief necessary.
The board has jurisdiction. For the applicant, John Bennett, Reed, 212 Windmill Lane, Southampton, New York. We were last here on May 5 presenting an appeal of a notice of a violation that had been, we submit incorrectly offered.
Yes, we should,
I'm sorry.
yeah, I was just going to mention, we wanted to also have both public hearings for number 7 as well at the same time.
That's where I was going.
Yes.
Okay,
Oh, okay.
that's fine.
Yeah, I'm
But
sorry.
we don't need to reread that because that's
Well, just say
already.
you're gonna open, you're also
Okay.
gonna open 7.
All right, so as part of this testimony, we're going to reopen number 7, which is SGM Excavating LLC and Max Masonry Supply Yard LLC.
Okay, thank you for taking care of that. So why don't I talk a little bit about the pending application, because we have some additional information. When we were last at this here, we submitted information demonstrating that the storage of mulch, wood chips, and hog logs at the property is an integral part of the excavation business. Indeed, we demonstrated that the applicant cannot comply with federal, state, and local requirements for the implementation of stormwater pollution plans unless mulch is utilized. We submitted copies of the 1972 SIC manual, which is specifically defined excavation. And I had submitted all prior permits issued by the Office of Fire Marshal for the storage of mulch, wood chips, and hog logs from 2015 to 2021. I also submitted a copy of the New York State standards and specs for erosion and sediment control, which specifically noted that the New York State DEC requires the use of mulch for stabilization to prevent runoff. This is a necessary thing in the village of Southampton, the town of Southampton, excuse me. And we need places like this. It's sort of like, people like Belgian block curbs, but they don't like to see the way the Belgian blocks are made. This is, I don't know, it's a good analogy. These are the heart and soul of the construction industry on the east end of Long Island in Southampton, and these are places that we need. This has been an ongoing use of this property, as we'll demonstrate to you further by some affidavits we've been able to obtain for quite a while. And certainly the CO is a one-story masonry frame construction building used in excavating and masonry business. So what did we do? It took me a little while because, the people are no longer owners of the property, but fortunately I've had a knowledge and awareness, having many years ago worked in my dad's contracting business, of both the two applicants that we've submitted to you, Jim Darby and James Duryea. Mr. Darby, as noted in the enclosed affidavit, his family was the former owner of the property going back to the 40s, previously owned both of the parcels. Mr. Darby is still in the masonry business and affirms in his affidavit that the sale of materials, including sand, gravel, and mulch, to both the trade and individuals and during his family's ownership was an integral part of the excavation and masonry business. Ongoing practices including the storage and sale of sand, gravel, mulch, wood chips to individuals and trade, and it's consistent with the practices that he engaged with on this very property during his family's ownership. So this is what's always happened there. And I can testify myself, I'm going to talk a little bit foreshadowing about James Duryea's affidavit. I went to Jim Duryea because that Duryea family has been involved in the same business for many, many years. The office that I sit in now was originally owned by a firm called Donnelly and Corrigan, and after that it was Duryea and Wild. Mr. Duryea's family has been in the construction business for years. My grandfather and from the 20s to the 50s, and then my father and uncle from the 50s until the 80s were involved in construction business, and we worked both with James Darby and James Duryea. And I'll tell you that, why am I bringing that up? Because I know the facilities. Mr. Duryea's facility, which is on 271 Bishop's Lane, it's not right near the railroad tracks. He no longer owns it. He sold it. But I remember going there, and the reason I went over there is because there used to be these bins. It was an excavation and masonry business, but to the trade and to the public, there were bins. You would drive the truck underneath the bins, and these weren't being used for construction or masonry jobs that they were using. They were sold to the trade and to the public. You drive underneath the bin, and the hopper would come down and put out run, gravel, sand, concrete. So Mr. Duryea says, for 70 years, we operated an excavation and masonry business at 271 Bishop Lane, in the town of Southampton. Is familiar with the existing masonry operation at 1010 and 154 North McGee Street. So not only is he telling you that that's what happened at his family's business, but he was familiar because the Darbys knew one another and the Duriers knew one another, as did everybody in the contracting business. I used to work for my dad. There were about 15 contractors out here who did all the work. Well, now it's a different story. But everybody knew one another, and they knew the trades intricately, and they knew one another's shops. They knew one another's business. So fortunately, both Mr. Durier and Mr. Darby can confirm that what has gone on there, which is not only storage of excavation materials, but also sale to the trade and sale to the public, has gone on forever. So it was sort of scratching my head when we got this notice of violation. But I wanted to have the board feel comfortable that we're not just pulling this out of our ear. This is what's going on the property, and I was fortunate enough to get one of the prior owners, the owner whose dad, Jim Darby's dad, in the 40s started the business. And in those days, you didn't need a CO. People say to me, do I need a CO? You don't need a CO for anything unless, let me back up. A certificate of occupancy. If I have a house that predates the code, I don't need a certificate of occupancy. Factually and effectively, I need it because when I go to transfer the property, someone's going to say, where's the CO? But if I have a house that predates the code, there's nothing in the law that requires me to get a certificate of occupancy. It's a practical necessity to transfer it when you refinance it, something like that.
To do any improvements on the property?
Exactly, to do any improvements on the property. But if you've got, there are still people that come to me in the village of Southampton, in the town of Southampton, to sell a house, and I'll say, where is the CO? I inherited the property from my grandfather. The house was built before zoning. I inherited, my dad inherited from my grandfather, and et cetera, et cetera, et cetera. And then we have to go get a CO for them. But there's nothing in the code that requires you to get it. So Darby's helpful because that's what happened. The Darby family is the family that commenced the use. The Swiderski family in the CO, they were the ones who eventually got the CO for the property, but it's a pre-existing CO.
But I just want to make clear for the board, because I've discussed
Yes.
this with you, the notice of violation that you have is on 2 properties.
That's right.
And the CO that you have is only for 1 property.
Yes, but thus my prefatory remarks. And then we did have, as Darby puts in his affidavit, an aerial photograph from 1962 showing both of those properties being utilized.
But and I just want to say, my position to the board is that speaks to whether or not he can get a pre-existing CO on the other lot. Like, I agree with John. You don't need a pre-existing CO. You don't need a pre-existing CO for your houses. You don't need a pre-existing CO for non-conforming uses. However, if code comes out and they challenge you and they say, we believe you're doing X and you're doing Y, I think that begs the question, maybe you should be getting pre-existing CO.
Well, that's why we have.
But this board can't issue you a pre-existing CO.
Yeah, but it's a really interesting thing, though, because for the use, I'm here for the variance for the trailer.
Correct.
But
On
for the
the
use,
lot that has the CO.
Yeah, for the use, there's nothing that requires me to get a certificate of occupancy for that other parcel. Would it have been wiser? Yeah, we could argue that, but that's why I'm giving you the information that demonstrates it now.
Yeah, but sometimes we'll hear a denial of an application for a CO or a certificate. And
Would you prefer that I go to the building inspector first? Or
I don't think
know.
you have to do it first. I just,
Yeah.
I believe, what I would say to the board is, I think it is going to be very hard for you to find that the notice of violation was issued improperly on the lot that has no CO, because the scope of the uses is an issue. So.
Yeah, no, it's almost philosophical at that time. It's like the Hendrix song, if 6 turned out to be 9.
Well, I think if the board said.
If the code doesn't require me to get the CO, you can't write me a violation for failure to do something that the code doesn't say.
But if
So the
you
options are
started doing
twofold.
something crazy on that lot.
Well, but the options are twofold. I'm not doing anything crazy on that lot. I'm doing what's always been done on that lot. The options are twofold. I can just go and meet with the building inspector and see if he'll give me a CO for that use, or we can do it in the context of this board, which might be where the building inspector would send me anyway.
He might, but.
But I mean, whatever you,
But wait a
whatever you guys
second,
want
I
to
don't
do.
understand. What you're asking for is the CO for the
No, I'm not.
non-conform, well, or for a recognition of non-conforming use on the second piece of property.
Yes,
Correct.
yes, and
All right.
thus the affidavits, which is the sort of
But
stuff
if
that I
we,
would.
if we, Yeah, but
Yeah,
we're
well,
discussing
they-
the violation.
They would, yeah.
They would do
Right.
that in response. By the way, they've
Right.
held the violations in the bands.
Yes, I understand.
Yeah.
And
Well,
some-
that's
and-
important.
Bob, just so you know, sometimes there'll be a violation, a town code violation in the justice court, and they send us here.
Send it here.
Yeah, yeah, so.
So I'm really, from a procedural point of view, I mean, it's as likely as not that the building department will send me here, but if you want me to meet with the building inspector on that issue, I can do it. I don't want to push your, position on it either way. I'll just talk about it, and I'll do what you want
Yeah,
me to do.
I mean, I believe that until you get, I'm trying to think of something that's comparable. If you believe you have a pre-existing CO for, like you do, like
Pre-existing,
pre-existing CO for the use of the property as A, B, and C, and then you do something that's not at all related.
Right.
The building department will say, you've changed the use on this, but you have nothing that's recognized as a use, and now you've
there's
added
two
something
different things
new.
we're talking about. Two different things we're talking about. One is the separate property.
Yes.
Okay.
That's the only thing I'm talking about.
Okay, but I haven't changed the use on it. That's what my affidavits are all about, that it's always been the same.
So you're giving us information as to what the uses have been.
Exactly.
And taking the
Exactly.
position based on those affidavits, that what currently is going on the property is part of that pre-existing use.
Predated.
Yes,
Exactly.
that predated zoning.
Exactly. And again, Katie, if
I
you
know
want,
what you're saying.
if you, I mean,
Yes, I would like you to apply for pre-existing CO for the use of 19 point whatever.
okay, we could do that.
Second one.
We can do that.
Because I think this board is only supposed to hear appeals, or,
Right.
or challenges, and this is de
Yeah, but
novo.
it-
The building department hasn't weighed in on whether or not this use exists. I know you have all the evidence of it. and
Okay,
I-
well,
Yeah.
I'll
I
meet with the building
agree.
department.
Yeah.
You want me to do that?
Yeah.
I think so. I
Yeah.
think-
You
want me to do that?
I think so.
That's with respect to number 7 on that, right?
That's respect to 7.
Correct.
Yes, right,
Correct.
right.
Okay.
Not-
Okay.
not one.
I'm not trying to
Put
make
it
work
all-
for you,
no,
John,
no.
but,
In terms of just keeping this all,
the-
keeping us all sane, do you want me to wait for the variance aspect as it too? Because maybe it should all be heard at once, because I should be back here, I could put the variance, the beginning of it in, but shouldn't we kick it all over until?
Well, listen, I understand, in the,
Just in terms of quasi-judicial economy.
I understand.
And I'm
Yeah.
not looking
Sure,
to
yes.
kick this thing down the road more than is necessary. Ideally, you guys would say, yeah, the proof is
But-
fine, but I understand your
But
procedure.
the violation is held in abeyance right now.
The
So I
violation is held in
think,
abeyance, yes,
Right.
Let's,
yeah.
let's clean
I
up,
spoke
let's
to-
clean it up.
Okay, I spoke to Sean Cambridge,
Clean it
and
up.
he said to me,
Yeah.
just come back to me when you're done with the ZBA. And I explained to him that I'm in the ZBA for both the variance and the violation. He said, come back to me when you're done with the ZBA. So would you prefer that I go to the building department and see if in their minds is enough to expand that? Because what am I getting a CO for? And are they then gonna say, yeah, but we don't think an excavation business and a masonry, excavation and a
Mulching and whatever.
we don't think a masonry business and a excavation business,
Right.
we're sort of back to where we were.
Yes.
Right.
I'm
But then-
saying,
but
yeah, of
then-
course it
But then you
covers.
come to us for the.
Then you
Okay.
come to us.
Yeah.
They say we agree with you or they disagree with you. They
Okay.
say
Right,
disagree with,
right.
with you, then we have an appeal.
but I do
We're
want
not
you to,
going anywhere, are you, Steve?
I do want you to discuss one thing, though.
Okay, sure.
Because this, I think, is important to the ZBA too.
Okay.
So the ZBA wrote, the building department initially wrote this up as
Right.
the trailer as being
Right.
accessory to
Yep.
the pre-existing use. And they wrote it up for accessory structure setbacks. Then we subsequently got a memo from the building department that was suggesting that they thought that the addition of the trailer was actually an expansion
Yeah, I
of
think
this
that's
now.
crazy.
I know, but
I'll tell
can
you
you
why.
just talk to the board a little
Okay,
bit about that? Because you do have a pre-existing CO for that big building, right? You have a pre-existing CO for a
Right.
use, and you have a
Yeah.
pre-existing CO for a one-story masonry and frame commercial building.
I understand.
Used in connection, and I think it is important for
Okay,
the board.
let me touch on that. I think it's a good idea. So Marge asked for certain stuff on the survey, and I'll get that. She wanted the northern trailer, the existing building, she wanted to notice that the frame shed is going to be removed, and et cetera, et cetera, et cetera. But then I get a letter from Art stating the gravel storage area and the office trailer consistent expansion of non-conforming use. So as clear from the historic aerials submitted with these affidavits, the storage of gravel, sand, and mulch and other materials has been ongoing on the property. So the existing storage is not an expansion of the pre-existing non-conforming use. It's just simply not an expansion. I don't know where he gets that from the code. The maintenance of the office building is not an expansion of the pre-existing use at a minimum, under that case I did many, many years ago. I'll hand it in. What the heck is it? It's that we got at Auto Parts case, where the whole area was, it was a junkyard, and the whole area was, the whole junkyard was, and we did some buildings there, and there was finding that there wasn't a pre-existing expansion of a pre-existing non-conforming use, because the whole area had been dedicated to it. So I don't see this as an expansion of the pre-existing use, certainly not an expansion these gravel areas. They've always been there, and we demonstrated that. So I'm not expanding a pre-existing non-conforming use.
But what about for the trailer?
As the trailer, I don't think it is either, because all I'm doing, we're gonna get rid of one of the two trailers, but all I'm doing is housing activity that was going on site, again, that we got at Auto Parts. But even assuming at the worst arguendo that it is an expansion, it's 32% of the there's an existing building there. We're at 32%. So even if it was an expansion, assuming arguendo, we're under 50%.
But is the nature of the excavation business similar to like sand mining? Like, does it contemplate the use of the entire property?
There's no sand mining.
No, but I mean, does it contemplate the use of the whole
Of course it
property?
does. You have to look at the aerials.
Okay.
Yeah, it's always been dedicated to that. It's an excavation business, stuff running around, I mean, it's always, when you go to a piece of property and you get a payloader out there or something like that, and the guy's digging and it's in a wetlands property, I like literally bless myself to make sure that they don't encroach into the wetlands, because these guys, I have some idea of how much area they use and need to operate, but these operators have another area. So the whole
Right.
site's been dedicated.
Yeah.
That's just the nature of the business.
So you kind of started in the beginning of the discussion about how, they don't need to have a certificate of pre-existing use. That is absolutely true. But the fact that they don't have it makes it, so that we've got to navigate all this now.
Okay, so let me move the building
yeah.
department.
Yeah.
But is that, that's my position on
Right.
Art's
But
letter.
I just had a couple more questions.
Okay.
Though. But so the building that's already there, what's in that building? They're actually like working out of that building?
Steve, come on up.
We have to swear you in.
The actual concrete building that's actually part of the CO and everything.
Yes, Steve Mezaneski.
Yep.
Yeah.
Okay, Steve, you need to state your address, Steve?
Yes, sir. Stephen Mezaneski, 110 North McGee Street, Southampton, New York, business address.
And do you swear to tell the truth, the whole truth, and nothing but the truth?
I swear to tell the truth, whole truth, nothing but the truth.
Okay, thank you. You can give us your comments.
So Steve Mezaneski is my son, Cole Mezaneski, owners of SGDP and what's the other name? Max Masonry Supply Yard. Those are the LLCs, but it's actual Southampton Excavation.
So what's in that building?
That building is utilized for storage of equipment and materials, as far as payloaders, so forth like that. Just a little quick history on
But wait,
that.
and then the
Steve,
trailer
no,
would be
Steve.
for office?
Yes, ma'am.
Steve, I'm sorry. I've
Yes.
been a litigator for 40 years. You're going to answer the question. You're not going to expand.
Don't offer
I
anything
know
else.
I know you pay.
Yes, it is.
Can you just look at
I would like to give a little,
Thing.
if I could.
Okay.
It's up to you.
No,
but you-
no, no, no.
Your
No,
attorney's
just answer-
advising you as to what you should and shouldn't do.
Answer the question, Steve.
Upside down for
All right, sure.
John, can you just, this is the ZBA thing you just gave us. Do you want those last two pages attached? I'm not sure.
This is the,
Okay.
The last two pages.
oh, no, thank you.
All right, so can everybody just rip those last two pages
All right,
off?
somebody copied too much. That's fine, thank you.
Oh, now I want to see what it is.
Do you have any more questions for Mr. Smith?
Yeah, so I was just gonna ask him if he could basically give his understanding as to what the uses are on the property. Is that, I don't wanna.
Yeah, I mean, you're asking him the question.
Yeah,
I don't,
yeah.
just,
Yeah,
sure.
so what and historically, going
right.
back.
Historically, we purchased the property approximately 21 years ago from Southampton Drainage, which was Jack Grief, and he had purchased it from Darby. Prior to Darby was Sarandowski. And the property has always had the same usage on it since Sarandowski, which is way back in time. When I purchased it from him, we purchased his company, his equipment, everything, and just went onto the property, and the same exact business that was going on there for 25 to 30 years prior to me. And so we did not change. The only thing we did was clean the property up significantly and obtain all the proper permits that were needed from the DEC, the town, the fire marshal, and which I'm a little confused by. For 20 years, Cheryl Kraft, somebody from the fire marshals came and did an inspection. Never said anything. Cheryl Kraft came to me one day and said, listen, we have this new permit you need to get for wood hog storage. We applied for it, got it immediately. Then all of a sudden last year, the fire marshal came in, did not renew our permit, and said, all of a sudden you're in violation.
And nothing changed.
Nothing said. So for 7 years in a row, we got the exact same permit for the exact same thing that's been done on that property for 40 years. All of a sudden.
More than 40.
40, more than 40. I mean, and it's been since Sandusky since the very beginning, and then all of a sudden, the new permit that they started issuing 7 years ago, they stopped issuing with no explanation and said you're in violation, which I cannot understand or comprehend. We're doing the proper thing and doing everything we're supposed to, and all of a sudden we're being told now we're in violation.
And what were the uses?
They've always been excavation, masonry, and it's exactly what's been used on that property since day one.
And how far back does it go, that use on that property, to the best of your knowledge? And I know you've only owned it for 20 years, but.
As far as I know, from looking at aerials and from the historic documents that I have, it's gone back to Sarandowski owned it before Darby, which is the 20s, 30s. Mrs. Trying to remember her name, the elderly lady next door used to bring us Christmas cookies, and her family owned it. She was Sarandowski, and I mean, she was a lovely lady. She used to bring us cookies and say, we're so happy you're here. I mean, we try to be very courteous of the neighbors. I know it's a residential neighborhood, and we try to do everything we can to sweep the street twice a day, keep everything neat and tidy, keep it closed in with gates, and keep the noise, the dust, everything down, and just be good neighbors.
I actually went to the site, and Cole was nice enough to show me around. It's very well maintained, it's very neat, a lot of traffic. I mean, the trucks come in, they dump in all the clippings or whatever, the branches, the logs, whatever, they all put them in a pile. And while I was there, it was being taken and put into a truck to take off-site to make into mulch. So you're not making the mulch there, is my understanding. And then on the side, there are different mulches with, there's different array of mulches on the side. There's gravel, it's truly, it's doing what it's supposed to be doing. I mean, there's no question. My question is, when you say that you sell to the trade, what is the trade? Is it just the excavation trade,
no,
or is it also the
anybody-
nursery business?
Anybody who comes in, sell to
Okay.
the public and the trade.
So it's not just wholesale, it's
No.
retail?
It's for excavation, people that are doing excavation jobs or jobs on sites, and they come in, or a large majority of it is for our own personal construction jobs.
But do you sell to nurseries, or, somebody comes in as a landscaper and he wants to buy the mulch, do you sell to the?
Yeah, it's part of,
Well, it's not just mulch. I mean, it's sand, it's gravel.
No, I understand,
it's
but,
crushed concrete, it's,
it's whoever
Okay,
wants
because
to
the
buy.
violation
Yes.
really specifically laid out mulch
Yes.
as being one of
That's-
being the violation.
That's
yes.
correct.
And as you saw, I don't understand the mulch, because as you saw, it's a small bin that has mulch in it. There's no
I didn't
large
see a small
mulch
bin, I saw
operation.
huge piles of mulch
Yeah,
behind the
but-
trailer.
Okay. that's it.
Yeah, there was not a bin, let me put it that way.
I mean, it's in two bins, it's not.
Yeah, all right, but it's,
My vision is the sand mines that have thousands of cubic yards.
Yeah,
there, which
yeah.
is-
Right.
so it's-
And, when we're in a situation like this, and we've dealt with it many times before, where there's a question as to whether uses are within the scope of what was used in the past, what was done in the past, or an existing CO or certificate of pre-existing use. Aerial photographs are very helpful, which I believe we have. Affidavits of people who were familiar with the property are very helpful. But that's all of this information we rely upon to try to figure it out, what actually transpired to the best of our ability. And the building department, it does the same thing, but they may not get all the information that we do. So, sometimes we'll have an application go to the building department, and then we'll have an appeal based on whatever decision is made, and we'll get a lot more information one way or another as to what happened. But that's really part of
Yes.
a process at times.
Can I be bold enough to ask, when I meet with the building department, do you want me to give you all this stuff and you want to consider, or you just want me to stay with the ZBA? Because sometimes they don't like to make the decisions. I understand.
Say it again?
Sometimes
When you go
they
to, when you go to the building department and you apply for the
Should I
pre-existing
just say to
CO?
them, do you want me to lay this all out and ask you for a pre-existing CO, or do you want me to keep it with the building department? I mean, with the zoning board.
The zoning board.
You know, Katie, sometimes they don't like to make the decision.
It doesn't matter to me, but we need something,
Okay.
if Sean doesn't want to do it, Sean should say, you know,
Okay,
take this to the ZBA.
I'll have
Because
to-
Yeah.
we need,
I agree.
we
When-
need to
when-
be appellate.
Could he
okay.
send us a
Yeah.
letter stating that?
Yeah.
Well, let me meet with him.
Yeah.
I'll show them all the stuff we have.
Okay, so
Office
then that's
trailer.
the decision, you're going to
As
the
long as
building
that's
department
Well,
first.
that's.
Before I
think
was
that's
there.
the direction
I
I'm
think
getting
it's
from
fair.
you
Same
guys,
trailer.
right?
Right.
So that's fine.
Fair.
I'm not gonna fight that,
So-
that's fine.
You know, and one thing that I don't, this property has a C of O for an excavation and mason business. That is my business, that's what we do. I cannot find another piece of property in the whole town of Southampton that has that exact CO. And that is the exact business we're in. We haven't changed anything.
Okay, well, we'll go speak to the building inspector and see if
Okay.
he's.
Yep, okay, thank you for your comments, appreciate it.
And John, is your idea to then bring it all back at once as opposed
just
to
trying to
doing it
I'm
half
just-
today and?
I'm trying to stop the, you know,
Okay.
it's taking a little, seems a little bit more efficient, a little less brain damage.
Yeah, and,
No, what do
you
you
know,
think? I don't know, Susan, you tell me.
I don't think you're being, you know, you're being upheld, you're being not allowed to continue your business. So I think that with that in mind, let's maybe just
Put it all
bring it all
together.
together
Yeah.
and bring it back and let's do it all at once.
Yeah, I'm in agreement with that.
Yeah.
We okay with that?
Yeah, and that'll give council a little more time to practice saying hog log. You struggle with that, I've seen
I
it.
really did.
I know. It's interesting.
And by the way, sometimes, I should just shut up and let you talk. But you did a nice job.
I know, yeah.
Yeah.
Lawyers are always very
We had to get you in
concerned.
the microphone if you're gonna chat with us,
That's okay. Lawyers are very concerned that their client's gonna say something.
Okay,
I don't have
all
to
right.
tell you.
And if you looked at the other notes that was made on the back of this from the building
From
department?
Marjorie.
Yeah,
On
she
the
wants some stuff on the
survey.
survey. We're
Yes,
working on that.
he had mentioned that.
And
Yeah.
a trailer's going to be removed and?
Yep.
Okay.
And
Yeah.
a shed and some other stuff.
Yeah,
We'll put it
yeah,
on there.
okay.
Um,
All right, so I just want to first ask, next ask, if there's anyone from the public who is waiting to be heard here this evening, who's here in person in connection with the two applications of SGM Excavating LLC. This is for property located at 110 North McGee Street in Southampton. I next want to ask if there is anyone who is waiting to be heard on Zoom in connection with the application, the two applications on the agenda this evening for SGM Excavating LLC for property located at 110 North McGee Street in Southampton. If you're waiting to be heard on Zoom, this would be the time to let us know by raising your hand.
No hands up.
Okay, all right, thanks, Charlie. All right, so next question is when would you like to come
I
back?
have a very busy September.
Okay. We have room on our agenda on, well, we have October 6th, but October 6th, the 7-Eleven application is
What's the
on.
next one?
October 20th?
That's fine.
Okay,
If that's okay with you folks.
that's
That'll give you some
fine.
time to meet with Sean. and-
Yep,
Yeah.
yep.
Yeah, and
And the
nothing's
legal-
being interrupted right now, so that's.
Excuse me?
Nothing's being
Yeah,
interrupted
no,
in terms of the
no,
business.
yeah,
Right.
I'm not trying to take advantage of that either.
No,
I'm
no.
trying to move it along, but
Yeah.
maybe
Okay.
this makes more sense from
Yep,
getting it all together. And then we'll hear them both, and they'll both be called at the same
yep, at
time.
the same time, and then by then, hopefully, we'll have many of these issues
Okay.
clarified.
And I spoke over you a little, some of them, my apologies.
Hmm?
I spoke over you a little bit. It's a
That's
problem
okay.
that I
We
struggle
used-
with
we
all the
used to
time.
that.
My apologies.
I do it all the time.
We're used to that. With you.
Okay,
We'll
so.
work on the hog.
All right, so I will make a motion that we put over, adjourn both applications for SGM Excavating LLC that are on the agenda this evening until our October 20th meeting.
Second.
Mr. Daly,
Aye.
Ms. Kern,
Aye.
Ms. Burtis, Mr. Macedonio.
Aye.
Chair votes aye. Thank you so much.
Enjoy what's left of the summer.
Thank you. You as well.
Yeah,
Take care.
It's over.
Thank you for your time.
Thank you.
Thank you. You too. Have a good night.
You know, it's frustrating to have a violation hanging over your head,
But
but
it's been in
it's got to be,
abeyance.
yeah,
Yeah.
it's got to be.
Number two, Susan.
Number 2, Fisher Organization LLC, tax map number 900-120-3-38.1, property at 74 Priscilla Avenue. Applicant requests the following relief from Town Code Section 330-11, Residential Districts Table of Dimensional Regulations for a proposed two-lot subdivision. One, for a proposed Lot 1, small I, a lot area of 10,000 square feet where a minimum of 15,000 square feet is required, and 2, small I, a lot width of 50 feet where a minimum of 100 feet is required, and 3, small I, a principal minimal side yard setback of 13 feet where 15 feet is required, and small 4, a principal total side yard setback of 26 feet where 35 feet is required, and any other relief necessary.
The board has jurisdiction.
Yep. Oh,
And I'd also like, just for the record, I'd like to just clarify that the advertisement should have said that the relief is for both proposed lots 1 and lot 2.
Yes, yes. Okay, good evening.
Good evening. Rachel Davy of Davy Law, attorney for the applicant.
Okay, if you can tell us about the application.
Absolutely. So this is a neighborhood in the Flanders town, and this particular neighborhood is consisting of many 0.1 or 0.2 acre parcels. Although those are non-conforming under the code, the historic history of the neighborhood reflects that size of a lot, and still are many existing today. As you can see, if I don't know if you still have the aerial. I know it was in the file folder from last time. The proposed 0.23 acre plots do fit the character of the neighborhood. They enable affordable housing to be provided to many of the residents. We're proposing, although we're not there yet, essentially the long-term plan is for 2 modest homes, no pyramid relief. And I think that really it will benefit the neighborhood where we have one large vacant parcel to present with 2 single-family homes, 6 bedrooms roughly, 1 story, brand new homes to the neighborhood that are like size and kind to the neighborhood.
Okay, so we do have, we have the aerial that came with the application when we received it. But the aerial that we have only just shows the lots to the adjacent lots to the west and the east. Are there other lots in the vicinity that are similar in size to what's being proposed?
There are many
Okay.
lots, both on Priscilla Avenue, and I believe the adjoining neighborhood as well has some similar situated and sized lots as well.
Okay. All right, so I know you mentioned you don't need any pyramid relief, which is good. So the relief that's being requested is lot area and lot width. And we do that from time to time on undersized lots within particular zoning districts. So my other question is, have you heard from any of the neighbors?
Have not. Oh, I don't know why my video went off. I apologize.
Yeah, it did. Oh, there it goes.
There
It's
we
on
go.
again.
We have not received any response, written or verbal, but telephone, nothing.
Okay, okay. Yeah, because, and when it's a subdivision application, we hear the variance part of it, and then the planning board hears the actual subdivision. So I'm not sure whether there are people in the vicinity that are concerned, but we'll find out soon enough.
I will add also, just for the record, this was just very similarly done on 91. 91 was subdivided. Same exact style house with the same exact relief requested before the zoning board for the lot area as well as the lot width, the minimum side yard, and the total side yard relief that we're requesting today. If it's not the exact same, it's extremely comparable. I believe the lots are identical.
Okay.
In size and the relief requested, but they will be the same homes as well, same style.
Okay. If you have that other decision, I don't know whether you've submitted it already, but if you haven't, feel free to do so.
Okay, we'll submit that.
Okay, okay. All right. Any other questions from members of the board?
Yes, I'd like, did you have a chance to look at Marjorie's comments?
I have her letter here. I believe it's just her letter with the current zone district.
Well, we have comments from the building department from Marjorie, and this is what.
Okay, don't have those.
You don't have that.
That was on page 2.
So this,
She has this on page 2.
it's on page 2 of what
Oh,
you
I
have.
see it, okay, survey,
Yes,
6 bedrooms. for
survey
each.
prepared by Nate Corwin, notes 6 bedrooms for each of the houses respectively. Floor plans were not submitted at the time of review, therefore compliance with required parking could not be verified. So if you have plans and you can go over them with Marjorie, that probably would be a good idea, and maybe submit them to us.
I saw
Okay,
plans. I think there were plans that were submitted.
So the plans that were submitted and on file with the town are not stamped and approved for this specific lot, but as mentioned, they are identical
Oh.
as lot 91 and 89, which were already submitted and approved, and they will be identical in a, same size and fashion, floor plan, et cetera.
But those plans showed 4 bedrooms, not 6. The survey showed 6.
Okay, so then maybe I'm confusing it with a different lot, because we have multiple lots on the block, and they're gonna be similar conformance, so I will get you,
Yeah.
I thought that I had sent them to Candace.
Was the revised plans? Are you talking about
They're not revised.
No, the reason why the plans need to be updated, the plans need to be updated because they are for a different property.
Yeah.
Okay, so we need
Absolutely,
plans.
understood.
So we need plans,
Right.
period.
Yes.
Okay, we will get you the plans, absolutely.
Yeah, and then if you can also reach out to Marjorie about those plans to make sure that she's satisfied with parking, the parking requirements.
Absolutely, I will do that.
Okay, very good.
Miss Davy, the reason I mentioned it to you is because, it looks like the building that we're talking about is 1,300 square feet. Now, I really like to see how you're putting 6 bedrooms,
Yeah,
if it is truly 6,
it's not.
into that space.
I'd love to see that too.
We're gonna see it with the plans when we get them.
And that's what I'm very,
One way or another.
I mean, I'm just interested in how somebody did that, so.
Understood, absolutely.
Some very small bedrooms, perhaps.
Very small.
Yep.
Yeah, also, Rachel, the planning board report reminds the ZBA about bringing in development rights for undersized lots. Have you looked into that at all? The planning board,
I
like
believe we're outside the scope of requiring those, but I think that was to be further discussed or investigated.
Well, if you can get us more information about that, I think that's something we just want to be sure that that's not something that's required. If it is required, then we
Absolutely.
have to talk about that further.
Absolutely.
Okay. Any other questions of members of the board? Is there anyone from the public who's waiting to be heard this evening, who's here in person in connection with the application of Fisher Organization LLC? This is for property located at 74 Priscilla Avenue in Flanders. Is there anyone from the public who is waiting to be heard on Zoom in connection with the application of Fisher Organization LLC for property located at 74 Priscilla Avenue in Flanders? If you're waiting to be heard on Zoom, this would be the time to let us know by raising your hand.
No hands, Adam.
No hands, okay. All right, thanks, Charlie. All right, so
This is Keith.
this was Keith's. We can keep it as Keith's, but
Hold
We
on
gonna
for
keep this
written.
open, or?
I think we might want to keep it open.
Yes.
It
For
feels
written
like
or
that,
keep it
yeah.
open?
I think keep it open altogether, because.
Keep it open altogether, okay.
Yeah, yeah.
She's got some work to do.
Yeah, so I think we'd like you to come back. So is there a better or worse date on our agenda over the next few meetings for you?
I think we should be able to get this together fairly quickly.
Okay, all right.
So,
Well, our next meeting is September 1st, if you want to,
hold on, I just gotta flip the calendar if you don't mind.
No problem, take your time.
September 1st at 6 PM would work.
Okay, very good. Okay, well, so Keith is not here, so I will make a motion that we adjourn the application of Fisher Organization LLC for all purposes until our September 1st meeting.
Second.
Mr. Daly,
Aye.
Ms. Burgess,
Hi.
Mr. Macedonio,
Aye.
Ms. Kern,
Aye.
Chair votes aye. Thanks so much, Rachel, have a good rest of your night.
Thank you, you as well.
Thanks.
Okay, number 3 on our new applications agenda is Trackus Realty LLC, tax map number 900-209-2-17, 405 Old Canoe Road Place. Applicant requests a determination that the subject parcel, Suffolk County Tax Map 900-209-2-17, is held in single and separate ownership from all adjacent parcels, and thus entitled to relief pursuant to Section 330-115D and any other relief necessary.
The board has jurisdiction?
Good evening.
Good evening, Karen Pate Murphy, attorney at law, 1 Bayberry Lane, Sag Harbor, New York, 11963. I'm here tonight with my client, Daphne Trackus, who is, it's a family LLC. They own property in the Shinnecock Hills, and we're here for a single and separate determination. This came about in that she wanted to sell her lot, 405 Canoe Place Road, her family's lot, to the town of Southampton. And I gave you there's a map here, and then there's a single and separate. And it was determined that this property was in the same ownership for 6 days from August 6, 1963 to August 12, 1963. So this was a title issue that's kind of prevented her from going ahead and selling this property, which is in an archaeologically significant area. It's vacant, and we wanted to clean this up, and she's going to be selling it to the town. It's also an odd-shaped parcel, so you know, it would be better that it be preserved. And also, the one that she's that was in the same ownership behind that, there's 5 acres of town land. So this is a kind of sensitive area. I wanted to show you the first page. They have, this is the lot. And you can see it's the one right up, 18.1 is the one that it was 6 days, it was in the family. And then I have the single and separate, and the first page, it's yellow. And then you go past the premises discussion, and then I made a mistake, I put a star next to it, but it shows that 17, which is 405, that you should look at the star. It was August 12th, 1963. It went from, before that it was in Louis Trackus and, how do you say it? Aspasia, beautiful named wife. And in February 2nd, 1963, and then in 8/12/1963, it was transferred to just Mr. Trackus. So that's lot 17. And then if you go over to the next page, which is 18.1, which is right above, the small parcel right above on the map, you can see that they bought it from Mr. Gerard Perello, and it's in both their names. And then you can, so that's what happened. And this is, you know, kind of a title issue, and in selling to the town, we needed to get that straightened up. This is in an area that's sensitive. It won't impact the neighborhood because it's going to be owned by the town. And the reason why it's on the CPF list is because it's an archaeologically sensitive area. The whole Shinnecock Hills area, whatever, it was put on the CPF list. So it's going to remain, you know, vacant in the CPS unless they do some kind of organized, you know, the college or something, a dig, or the Shinnecock Nation.
Yep.
And there hasn't been any joint use. The upper parcel does have a house on it, and they have in their deed an easement that allows them access to Old Canoe Place Road, which is really kind of a dirt road. I've only heard from one neighbor that is at 18 Baconic Road. I'll just put that in. He lives across the street, and haven't heard from, Ms. Trackus hasn't heard from anybody. So I think there's a neighbor here
Okay.
that might want to say something, and,
Okay.
you know, respectfully, you know, request the single and separate.
What you submitted, the pages, is this the full single and separate search?
It is.
Okay, good.
Yeah, no, all the deeds, Candace suggested that I don't
add all the deeds. that
Yeah, we don't have to
thing.
have copies
I
of the deeds,
emailed.
just the breakdown.
Yeah, so just the breakdown. I
Yeah,
wanted to-
yeah.
And I put them next to
Okay.
each other.
Okay.
But all the other ones are separate, and.
Okay.
I looked at it, Adam, because I
Yeah,
noticed we
yeah.
only had the 2 pages.
Yeah, yeah.
Yes,
Okay.
so, no, sorry, yeah, originally I made a mistake, I don't do this too often, so.
Yeah.
Anyhow, I apologize,
Okay,
but,
so, all right, so the subject parcel's vacant land. There's a period of 6 days where it was alleged to have been merged with an improved property to the north.
Yes.
That correct?
yes,
And there aren't any accessory structures of any kind on this vacant lot?
no,
Okay. Separate tax map numbers?
yes,
Separate deeds?
yes.
Okay. Not used in conjunction with one another?
No, they're just to access, there's
Yeah.
just an
Okay.
easement that's run
A
with the
deed-
property.
Right,
Yeah, that's in the deed,
okay.
That'll remain once the town purchases it, whoever
yes,
purchases it?
yes.
Yeah, yeah, okay. And just one other question, the property with the house on it, do we know if there was ever a mortgage for that house? Because if there was a mortgage that just had covered that other lot and not the vacant lot, that would be evidence in your favor as well.
There was a mortgage.
There was a mortgage just on the,
The house.
yeah,
Okay,
you have to
okay.
swear in.
Yeah, it's just swear in, if you can
swear
state your
in.
name and address.
Daphne Truckus, 64 Hilltop Road, Southampton, New York.
And do you swear to tell the truth, the whole truth, and nothing but the truth? Okay, so really, the mortgage would only be useful for us is if it was in place during those 6 days. So, it was, okay. Well, if you can submit a copy of that mortgage.
Okay, you have it?
Yeah,
Oh, she doesn't know, her father passed away.
okay.
I'm sure there's no mortgage
Recently.
now. It's paid off.
Oh,
Yeah.
no, he was very happy. Now
Yeah,
he's
but I mean, it would be,
Okay.
it would be of record in the county clerk's office.
Oh, that's true, right.
Yeah,
Okay,
yeah.
yeah, so if you could,
If you could
Yes.
get that and submit that to us,
okay. yeah.
I mean, that
We can get
really-
that, yes.
Yeah, I mean, that does it on, even separate from the other questions I asked
Okay.
about.
And it was just on that property, just the house, yes, okay.
Okay,
Okay,
yep,
thank you.
all right, and that's
Okay,
it.
so okay.
Yep,
Might be somebody from the public here.
we shall find out. Any questions of members of the board?
No.
Is there anyone from the public who is waiting to be heard this evening in connection with the application of Trackus Realty LLC? Ma'am, feel free to come up. You have to go to the microphone, either to the podium or have a seat right over here.
I'm
So,
Dale Nickel.
okay, I just have to swear you in. If you can state your name, your address, please.
Dale Nickel, 399 Old Canoe Place Road, Southampton.
And do you
New
swear to
York.
tell the truth, the whole truth, and nothing but the
I
truth?
do indeed.
Okay, you can tell us your comments.
I am right across the flagged lot from this property.
Mm-hmm.
As long as it stays green, I'm absolutely for the petition.
Yep.
And I can say, talking to my neighbors, as long as it stays green, we all agree.
Well, it's going to be owned by the town when all is said and done.
Sounds good.
And hopefully, that's exactly what's going to happen.
Great.
Okay.
We appreciate that.
Okay, all right, thank you.
Thank you.
Appreciate your comments. Okay. Is there anyone else who's waiting to be heard here in the room in connection with the application of Trackus Realty LLC for property located at 405 Old Canoe Place Road in Shinnecock Hills? Is there anyone who is waiting to be heard on Zoom in connection with the application of Trackus Realty LLC for property located at 405 Old Canoe Place Road in Shinnecock Hills? If you are waiting to be heard on Zoom, this will be the time to let us know by raising your hand.
No hands.
Okay. If not, Helen, it is yours.
Okay, I think we can close the hearing, the public hearing today. We'll leave it open for written submissions till September 2nd, and we'll have a decision on September 15th.
Second.
All right. Well,
Ms.
thank you very much.
Thank you.
Thank you.
Ms. Burgess.
Aye.
Mr. Daly.
Aye.
Ms. Kern.
Aye.
Mr. Macedonio.
Hi.
Chair votes aye. Thank you both. Have a good rest of your night.
Okay, thank you.
Bye.
Number 4,
Can I just
sorry,
ask
go
Katie,
ahead.
can I ask Katie a question?
Yeah.
Why wouldn't something as simple as this with 6 days be considered a minor variance that wouldn't
Because, well-
require?
It's not even a variance. It is an interpretation
That's why.
of whether there was a merger or not.
The minor variances are defined in the town code, and they say less than 25% of anything from 330-11, so.
But,
And this was important for them because they wanted to have a sale of the CPF as well.
yeah, and these kinds of applications, and we have another one of single and separate
know.
determinations, are not variance applications at all.
They're not
They're
variances.
interpretations of whether there was a merger of two lots that had a period of time of common ownership, whether that be 6 days or 12 years or longer. There is a case law that we have to follow on that. So it's these kinds of applications are a different thing, different kind of application than the variance applications we hear for area variances.
And that just couldn't be handled administratively without requiring a hearing?
There's no such
No,
thing.
no. We're following case law in New York State in doing what we're doing.
Thank you.
Yeah, no problem. Good evening.
Number 4 on new applications is Eric Newendorf, tax map number 900-290-2-12 at 8 Seashore Avenue. Applicant requests the following relief from Town Code, Section 330-11, residential districts tables of dimensional regulations for a proposed garage attached to an existing dwelling on a non-conforming lot. 1, a principal front yard setback of 17.2 feet where 40 feet is required from the northerly property line, Quogue Street. And 2, a principal front yard setback of 38.2 feet where 40 feet is required from the easterly property line, Seashore Avenue, and any other relief necessary.
Board has jurisdiction?
Thank you. Good evening.
Good evening.
I'm Susan Wolfersdorf, attorney for the owner. P.O. Box 429, East Quogue, New York. Telephone 631-728-6894. And I believe the owner, Eric Newendorf, is with us via Zoom.
He is.
Okay. The subject property is located at 8 Seashore Avenue in East Quogue. It's a non-conforming, undersized lot of 10,000 square feet in an R20 zone. There's a certificate of occupancy for the existing one-family dwelling. We have a certificate of compliance for the deck and the pergola, and a certificate of compliance for the in-ground pool and with the code-compliant barrier. This board granted a variance in January of 2021 to allow a proposed pool to be built 17.5 feet where 50 was required from the street setback, and to allow the pool to be located within the required front yard. We're requesting the variance to construct the proposed 2-car attached garage with the relief of the 17.2 where 40 feet is required from the northerly property line of Quogue Street, and 38.2 where 40 is required from the easterly property line of Seashore. The reasons we are requesting the variance and are following the practical difficulties, all of which are not self-created. The size of the lot, as I said, is non-conforming. It's only undersized of 10,000 square feet in the R20. And the fact that this lot is a corner lot, it has 2 front yards, and it has to comply with 2 front yard setbacks. And the proposed garage, there's nowhere on this lot, given those problems, that it could be built in a conforming location. The request that we're asking of the 38.2 feet from Seashore Avenue is, the reason we're asking for that is we wanted to leave enough room to get access to the utilities, which are right on the northwest corner of the existing dwelling, and also to have access from the driveway and the pool gate, which have enough room for that pool gate to, open outwards as required by code. I think that was, we also submitted 4 signed letters from 4 of the surrounding property owners stating that they have no objection to this request for the variance. And we just wanted to point out that the proposed attached 2-car garage is also modest in size and will be keeping with the character of the existing neighborhood.
And no pyramid relief, I see.
Excuse me?
No pyramid relief?
No.
No, that was,
Marjorie
And I
did
just
bring
set the
that up.
story in, if you can, if you can state your name and address.
Edward Wolfersdorf, 2 Sarah Lynn's Way, P.O. Box 429, East Quogue.
And do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
Okay, so if you can tell us what you want to add.
The plans show that I designed the garage to meet the pyramid, to be lower than the pyramid, and the property is almost perfectly flat according to the surveyor, so I showed that on the plans, and there's plenty of relief on either side. I also have a photograph of the side of the...
Are you submitting it?
Yes, we have.
Sure. That would be the side of the house that faces Clark Street, where the garage will be. And if you look closely, on the right-hand corner, there is an oil fill about a foot off the corner. And I'd like to submit this as well. It's a picture showing the same corner with the pool fence. So it would be a hardship, not a hardship, but it would, difficult to get alongside the garage into the pool area without that 1 foot, for the oil delivery man. And it would be a difficulty to move the tank. We're just asking for about 1.5 foot of relief on the east side.
Yep.
I did have one question, because the address is Seashore.
Yes.
The access is off of Quab.
For the garage, yes, it is.
No.
Yeah.
Entrance to the house looks like it's on Seashore.
Faces Seashore.
That's
Yeah.
Right.
To me, it's a pretty modest application, but we'll see if,
Okay, just wanted to make-
yeah, we'll see if any of the neighbors are
Okay.
going to, are here on Zoom. Okay, or in person. Okay, any other questions from members of the board?
No.
Is there anyone from the public who is waiting to be heard here in person in connection with the application of Newendorf? This is for property located at 8 Seashore Avenue in East Quogue. Is there anyone who is waiting to be heard on Zoom in connection with the application of Newendorf? This is again, for property located at 8 Seashore Avenue in East Quogue. If you're waiting to be heard, this would be the time to let us know by raising your hand.
Oh, yes.
Okay. If not, Bob, it is yours.
Mine, we will hold open for written submissions to 9/2. with
Yep.
a decision on 9/15.
Yep. I just forgot to mention one thing. We did have a comment from Marjorie Riley, building inspector. The shed on the south side of the property does not benefit from a certificate of compliance. As such, this shall be addressed with the building department.
We already had the
Yep.
shed, the owner had
Yep.
the shed moved.
Okay, no problem. Okay, so you made a motion. Do we have a second?
Second.
Okay. Mr. Macedonio?
Aye.
Ms. Kern?
Aye.
Ms. Burgess?
Aye.
Mr. Daly?
Aye.
Chair votes aye. Thank you both for being here. Have a
Thank
good
you.
rest of your night. Take care. Oops.
Okay, next on new applications is Ziggy Ben Heim, tax map 900-24-3-26, 4529 Noyak Road. Applicant requested determination that the subject parcel, Suffolk County tax map 900-23-3-26, is held in single and separate ownership from all adjacent parcels,
Well, I
and thus
think
entitled to
nobody
relief.
objected to anything, and nobody's made any comments about anything,
Just
so.
mute that person.
But they said if you want to speak, raise your hand,
hear
but I
you.
don't have a raise my hand thing here.
Okay, which application are you here
Previous
on?
one.
The one that we just heard?
Now you can unmute him. Did we ask if there was anyone on
We did.
Zoom? for
We
the
certainly
previous-
did.
Yeah,
We
We
did.
certainly did.
They're done.
8 Seashore.
Okay.
Okay, I'm going to continue reading.
Well, hold on a second. If this person is on for the last application, we have to vote to reopen.
It was the applicant.
Oh, it was the applicant. Oh, okay.
He was probably
Yeah.
just
He was
doing a recap.
Talking to somebody else.
Oh, okay,
in his
oh,
room.
okay. All right, no problem. Then let's keep
Okay.
going.
Next.
So we're trying to decide if this is held in single and separate ownership from all adjacent parcels and thus entitled to relief pursuant to Section 330-115D and any other relief necessary.
Board has jurisdiction.
Yes, whenever you're ready,
Mike?
Bruce. Okay, if you can state your name and address.
Bruce Anderson, Suffolk Environmental Consulting, in the office of Main Street, Bridgehampton.
And do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, we do.
Thank you. If you can tell us about this
I'm gonna just
application.
stand up our exhibits here.
Okay,
We'll take them off.
Shouldn't he have like a blanket
Okay.
weigh in by now?
So we're requesting termination at subject health is held in single and separate ownership of all adjacent parcels. The property that contains 14,821 square feet or 0.34 acres and is located in an R15 zone. Thus, the parcel is undersized by 179 square feet. Almost nothing. The cause of the reduced lot area is the apparent erosion of the shoreline by 1.8 feet over the last 50 years.
50 or 15, you said 50?
50 years, yeah, 1.8 feet is what it calculates to. The lot otherwise complies with the R15 zone in all other respects. The single and separate provided with the application indicates that the lot was held in common ownership to the east up to September 28th, 1968. The easterly adjacent lot is described as 4539 Noyak Road, Suffolk County Tax Map 0900-24-3-27. Thereafter, the parcels were held in separate ownership. Records review indicated the original dwelling was constructed for the eastern lot prior to June 27, 1974. The single and separate also indicates that the lot was held in common ownership of the adjacent lot to the west up to September 1st, 1969. The westerly lot is described as 4519 Noyak Road, or tax map number 900-24-3-25. Thereafter, the lot was held in separate ownership from subject parcel. And the records indicate that the original dwelling was constructed prior to June 5th, 1971. All these lots were created by deed, and a review of the 1957 zoning map reveals that the area was zoned C residence, which would have required a lot area of 15,000 square feet. In other words, the zoning's never changed on here. It's R15 now. We have a residential neighborhood and characters dominated parcels of similar size. It's a vacant lot. The handed out exhibits here, and the property has tax map designation, has been assessed and taxed separately from adjacent lots, and has not been used in conjunction with either adjacent parcel. So in my exhibit, I show you the tax map, and you'll see it has its own tax map. You can see the adjacent lots of similar size on each side.
Yep.
Okay. The second exhibit is an aerial photograph. It shows the wooded lot, and you'll see that there's a boat here that kind of washed up, but it's not used in conjunction with either lot. The third exhibit is shots I took today. It shows a house, wooded, shows a vacant wooded piece in the middle, another house on the other side. Again, no evidence that they're being used in conjunction with one another. I then provide you with the tax assessments for all three lots. They're all different.
Thank you, Mike.
That is essentially our request. We don't think it materially affects the neighborhood. The amount of relief is so tiny that even will easily comply with all the R15 setbacks in any event. It is a waterfront lot, and it lost, I guess, about that much in 50, 60 years.
It's even possible that during the period of common ownership, it conformed, right?
Probably did, because
Yeah.
the others got building permits. So we don't know when it became non-conforming
Yeah.
for that small amount of area.
Wow, wow, okay. Well, I think you covered the bases. It appears to me that, it is, we'll make the interpretation. I think that's what's going to happen, but we'll wait till the
Thank you, sir.
vote takes place. But also before we,
I do want you to know, too, that we did receive a call from, I guess it was the son of the adjacent property owner to the east, and that would be, give me a sec here. The name is, the Pauls, who have owned the property since 1968. She's quite elderly, and spoke with her son. Didn't express any objection, only that the R15 zoning would be, sort of remain in place, and it actually does, because that was the only comment. Matt from my office spoke with him, I did not. He should be aware of that as well.
Okay. Any questions from members of the board?
Are you
Okay.
asking for variance relief on the size of the lot?
No, I'm
as
asking
well?
for determination.
Only
Determination.
separate, all right, because you
This is
keep
like the other
mentioning
one.
that, that's why I keep wondering why,
Yep, this is a determination.
All right,
It's
so-
not
okay.
really a variance, but the
Variance.
result is uniform.
Correct.
Yeah, yeah.
Uniformity in the neighborhood.
Correct.
Which is zoning.
So basically, Bruce, covered, the questions that I had asked in the other application.
Right.
Was there an intent to merge,
Right,
essentially?
right, no, I get that. I was
Yep,
just wondering, he
yep.
keeps talking about the loss of the land, and I was wondering like whether you, but you're just saying, you're just coming for the separate.
Yeah, and it's a tiny amount.
So
Yeah.
just,
And it'd be
Really,
very,
really
yeah.
small.
if that's granted, then they went to get a building permit, they have to get a variance for the size?
No, it's single and separate. And what happens is we would just simply follow the R15 zoning, because when you apply 3/10, for example,
But it's.
it's the same as,
Okay.
it doesn't
Yeah,
do
but
anything.
He would apply the setbacks, but the size of the lot
Size of the lot
would be
would be
smaller.
slightly
But what he's
undersized.
saying,
Okay,
what I
just-
think
yeah.
you're saying is that it's such a minor amount that it would fall under the minor variance?
No, it's not really a minor variance, but it is,
But it's not going to really
minor.
impact, setbacks shouldn't be an
no, it
issue.
has no impact on
No, I
setbacks.
understand, but do we have to make an exception because of the size of the lot?
No,
Okay.
no,
That's what, okay.
nope.
No.
Nope, we can make these determinations on lots that do not comply with whatever current zoning is. Yeah, and in this instance, it
But
slightly
I'm
slightly
involved.
doesn't.
When he goes to get a permit, is he gonna have to come back for a variance
It's
on
not
the
gonna,
size?
it's not gonna meet the
No.
R15 requirements,
He's not gonna meet the R15.
requirement.
No, I will
Because
actually.
the lot
because
shrunk.
It's so small.
It's everybody, it's
You
every.
will-
Okay, okay.
Every
You will
single-
automatically meet those requirements.
Right,
That's fine.
Okay,
I'm okay
okay.
with it then.
yeah.
We're okay.
Yeah, okay. All right. Is there anyone from the public who's waiting to be heard this evening in connection with the application of Ziggy Ben Haim, I hope I'm not mispronouncing it, for property located at 4529 Noyak Road in Noyak? Is there anyone who is waiting to be heard on Zoom in connection with the application of Ziggy Ben Haim for property located at 4529 Noyak Road in Noyak? If you are waiting to be heard on Zoom, this would be the time to let us know by raising your hand.
No hands.
Okay. All right. If not, Mike, it is yours.
Okay, we'll close this public hearing, leaving it open for written submissions until September 2nd, with a decision on September 15th.
Second.
Mr. Daly.
Aye.
Ms. Kern.
Aye.
Ms. Burgess.
Aye.
Mr. Macedonia.
Aye.
Chair votes aye. Thanks so much, Bruce.
Thank you very much.
Have a
Thank
good rest of
you.
your night.
Seeing you.
One more.
Oh, you got one more?
Okay,
Okay, we'll see you in a bit.
Yep, thank you, sir.
Holdover applications number 6, Blessing Fields LLC, tax map number 900-2222-1-12 at 163 West Montauk Highway.
Good evening.
Good evening, board members. Wayne Bruin, O'Shea, Marcinson, and Bruin on behalf of Blessing Fields LLC. As your agenda indicates, this matter was last on your agenda in February. At that time, the board had adjourned this, in particular adjourned it for the purpose of coordinating under seeker. And you did coordinate with the planning board, who has assumed lead agency. And since then, we've been working with the planning department on the review under seeker. Just to bring you back up to speed, this property is a 49,554 square foot lot, 1.14 acres. It is 74.1 feet wide, 800 some feet long. It's on the south side of Montauk Highway, north side of Long Island Railroad, 380 feet west of the Riverhead Hampton Bays Road, State Road 24. And it's across the street from the shopping center where Macy's and the other stores are. It's located in the highway business zone. And you may be more familiar, just to the east is the Quag Sinclair Fuel Service, and on the west side is the Riverhead Building Supply. The subject property was originally improved with a 1,700 square foot frame building erected as a model home with a garage, a detached garage building. The buildings were later converted to commercial use for the sale of household appliances, and then subsequently for offices and storage for a special trade contractor. The proposal, we started with a pre-application at the planning board. The applicant intends to demolish the 2 existing buildings, build 2 new structures to house offices and warehouse shops for a special trade contractor. The front building we originally proposed, as per the notice, had a footprint of 2,182 square feet and was going to be the primary spot for office use. And then the rear building with a 4,000 square foot footprint was going to be used more or less for the warehouse shop space for the special trade contractors that would occupy the site. As I mentioned at the beginning, it has a 74.1 foot lot width. That narrow dimension, it is a pre-existing single and separate lot. And the fact that why we're here is an oddity in the code. It's an interesting oddity, the pyramid law for a commercial facility. In 1992, when the town adopted the pyramid law, it specifically excluded certain commercial zones, including the highway business zone. From 1992 to 2008, many properties were developed, narrow lots like this throughout the town, and never had to address pyramid. After 2008, though, the town board amended the code, and there was really no rationale, but they struck that exception for highway business. Notwithstanding, zones like Hamlet Office, Hamlet Commercial, Office District, all these are still excluded, where you would think have more of a residential setting where solar access and light and access with adjacent buildings, which is the primary purpose for pyramid, is the goal and the objectives of the code. Nonetheless, here we are. That's what the code says. Highway business, now any buildings in the highway business zone must comply with pyramid. So this was identified by the planning board when we did a pre-submission review for the redevelopment of the property. The biggest issue for the planning board, and I remember years ago when the conversion from the model home to the various commercial uses, was the fact the location of that front building left a very narrow access on the easterly side. So the design here was triggered and prompted most by the fact that the planning board wanted to get a wide enough access, at least 24 feet in width, which is their normal on the easterly side of this property, which basically pushed the buildings to the westerly side. Under the provisions of the code, single and separate would allow a side yard of 11.85 feet. What the applicant we had originally proposed was a 10-foot setback. And as a result of a 10-foot setback with 2-story buildings, you can imagine we ran into pyramid. The original relief on the front building was 4,755 cubic feet. The rear building was 14,107. So, as I mentioned procedurally, this board, you heard our application in February. Under seeker, you coordinated, and the planning board, in the last few months, the planners and the planning board looked at the application. But more importantly, this board asked us to go back, like you do on all pyramid, and see if there was anything that could be modified in the plans to maybe address or reduce the amount of pyramid relief. That being said, my clients went back and they did change the plans. And that, and I'll explain what those changes were and the relief that we're now asking for. But more importantly, with those changes and some other changes which were related to the architecture, which the planning board want on the front building. They were concerned about the appearance along the street and wanted some tweaks and changes to the building. With all those, the planning board last Thursday adopted a negative declaration. I don't know if you received a copy of that from the planning board at this point? I think you did.
We did.
Okay. So that would allow this board to proceed at this point and seeker, so the negative declaration, no adverse environmental impact is expected from the project. With respect to the front building, I mentioned the architectural changes. The building height was not reduced. It was 26 feet where 35 feet is allowed. But the front building was moved from the 10-foot side yard to a conforming 13.3 side yard. So we're not asking for the side yard relief for that building anymore. They did also, so they not only shifted the building, but they also reduced the width from, of the building from 31.2 to 30 feet. Those two changes also, you know, again, the key with the planning board is maintaining that access. So what happened is not only a little bit on the building, a little bit on the side yard setback increase, but they lost a little bit of the landscaping that was on the easterly side of the entranceway, and they also lost a foot on the sidewalk. It still meets code requirements, but they were where they were able to tweak that. As a result, the footprint of that building decreased, and the pyramid encroachment on the front building was decreased by 1,759 cubic feet from 4,755 to 2,996. And by the way, we submitted this week, InterScience, on behalf of the applicant, submitted a letter dated August 17th with all these new plans and a letter explaining that. And I believe Mike Sciano from InterScience is with us on Zoom. So if there are specific questions about anything we're talking about, he can jump in at that point. With respect to the rear building, we also moved that building from the 10-foot side yard to a conforming 12-foot side yard. And the building height was reduced from 25 feet to 23 feet, again, where 35 feet is required. And that allowed the pyramid encroachment of the rear building to be decreased by 2,107 cubic feet from 14,107 to 12,000 cubic feet.
Is that the office building or the general trade?
That's the general trade, yeah. The rear building, yes. So essentially, totally, we reduced the pyramid relief that we originally requested by more than 20%. And again, the variances that we're now seeking no longer are the side yard setbacks, only the pyramid relief.
They're both two-story?
The front building is two-story. The second building has a mezzanine within it, partial mezzanine, but it is only 23 feet in height. Just by comparison, and we provided in the plans, in the diagram, there is a side-by-side comparison. It shows sort of the Riverhead Building Supply building to the west, which, when that was constructed, no pyramid issues there. That, you know, it's a larger lot, obviously, but the building is approximately 243 feet in length. It extends along about 120 feet in width. It's a 27,154 square footprint with a almost 4,000 square foot mezzanine in their building. It's over 30 feet in height. It's a larger lot, and they were able to have a conforming 20-foot setback. If they were to apply for that now, they would be seeking 8,500 square feet of pyramid relief. And even though they have a larger, more conforming lot width and so on. The buildings, again, are dwarfed. I mean, the size of these buildings, when you look in comparison, you can see how the Riverhead Building Supply building to our west dwarfs that. As I mentioned, none of the changes to the plans impact the aisle widths, the access, the off-street parking, all of which will be addressed by the planning board. Again, if this board is inclined, we will, our next step would be to go back to the planning board for a final site plan, and they will deal with landscaping and all the parking requirements, drainage, SWIP, you name it, curb cut with the DPW. We did receive, the planning board, when they coordinated also, they received comments back from all those agencies as well, and they're going to incorporate those into the site plan. So I hope we were attentive to your concerns, but again, I think this is unique. You're not going to find many applications, I would think none. Not too many parcels in the highway business have a narrow width like this of 74 feet. I remember, if you're familiar, to the west of this property, there is a 50-foot wide highway business parcel that was adjacent to the power lines, and there was a basket weaving kind of building built on a 50-foot wide parcel, and I remember that building, a large building, would probably never have been able to comply to any pyramid at the time, but nonetheless, it was something that received variances by this board. But again, this pyramid issue only became important in highway business after 2008.
Mm-hmm.
So if you have any further questions, I know there's a lot of information here in the plans and details.
Okay.
I have a question.
Sure.
I thought I had the most recent site plan, because it's in this big packet. I think the one that I'm looking at is last dated May 19th. Does that sound right, or is there one after that? Because that's my first question.
Site plan, I think.
May 19th, 2022 is correct. If you need to swear me in, I just wanted to.
Yeah,
just
I
thought
do.
would-
So if you can just state your name and address for the record, please.
Sure. Michael Shiano from InterScience Research Associates in Southampton, 36 Nugent Street.
And do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Okay, thank you. And if you want to add to your comments, feel free.
So my question, Mike, is so that I'm looking at that site plan, and the planning board is talking about, they summarize the project as saying, proposes construction of one two-story, 2,180 square foot building to be utilized for 2 office uses and one two-story, 4,000 square foot building. But that's not even close to what the site plan says.
No, and I think they're referring to the footprints.
Okay.
Because the footprint, and we noticed that too, and we only, that only happened last Thursday, so I didn't have a chance to even see what they said, but the point is, the site plans are identical, but the front building has a 2,000, what is it, a 2,000?
2,100 square foot footprint.
Correct. And the back building has a 4,000 square foot footprint, but it has the 2,000 square foot mezzanine within it. And so the 2-story, and there's also basement and partial finished basement on the front, so total, that's why you see on the site plan, in fact, I think there's a little table on the first page
Yeah.
that tells you the floor area of each.
And is the reason that they can't be pushed more into the middle of the site is because then you just can't get around it? You can't.
Exactly.
Can't do the
The
flow?
planning board wants the 24-foot aisle on the east side.
Right.
Currently, I think it's like 12 to 14 feet, and it's always been not something that, it's
Yeah,
sort of
yeah.
a one-way access.
Yeah. So this is a very unusual kind of application, as Wayne had indicated, okay? In most of the business districts in the town, there is no pyramid requirement at all. So for whatever reason, and we're not here to question what the town board did, but the town board, for whatever reason, decided to reinsert pyramid into this district, the highway business district, whereas it doesn't exist in lots of other business districts in the town, probably most of the business districts in the town. So this is an unusual parcel that is a commercial property looking for pyramid relief. That's unusual. And as to the way we look at these kinds of applications, which are going to be very rare, and Wayne may be right, this may be the only one, or there may be a handful of others in the years ahead, I think should be looked at a little bit differently than for residential properties. That is, generally, the purpose of pyramid relief is so that neighbors aren't on top of each other, so that they have views, so that they have, they're not feeling constricted. I think generally that's the purpose of pyramid. With a commercial property, I'm not exactly sure if that should be looked at it in exactly the same way, but it's up to us. I mean, there's a lot of discretion here as to, what we think should happen in these commercial districts as opposed to residential districts. And by that, I'm not saying that we shouldn't care about the pyramid at all. I think we already indicated that it was, we needed it to be reduced, and they've reduced it to an extent. But it is a big number. It is a big number. Without a doubt, it is a big number. We do not, we've rarely granted, on residential properties in my years on the board, these numbers of relief, particularly for the 12,000 cubic feet. The other one that's now at 2996 is within the range of what we, kind of on the low end of what we hear. But normally, when we're going in the range of 8,000 plus, we become increasingly reluctant to grant the relief, and we asked applicants to make significant changes. That's what we regularly do. They've made some changes, but it's not down to the range of what we would normally want on a residential property. But it's not a residential property.
I agree. It's not a resident, it's a narrow lot, and it's got a very big, tall building right next to it, so you're not affecting their light and air and everything else.
We're not gonna be setting off a trend where people are gonna be coming in because it's rare, it's gonna happen.
Right. And further, Wayne is making the argument, and I think the argument can be made, that on properties in this particular district, there are other properties that didn't have the pyramid law in effect at the time, and, don't comply remotely with pyramid because there was no pyramid law for a period of years.
Right.
Yeah.
So
If I
one
may,
can,
I just want to add one, so I have the actual local law of 92, and
Yeah.
it said that the erection of buildings or structures along the minimum setback lines at the maximum height allowed under the code can inappropriately impair solar access to surrounding sites, upset the harmonious balance and architectural character of well-established neighborhoods, and adversely impact visual and aesthetic qualities of the town. These problems can become more particularly acute when undersized or narrow lots are developed. So those were the purposes. Now, the interesting thing is, at that time, highway business was not included. And the only other commercial zone is the RWB zone, which is interesting, because when you look at our RWB zones, most of that is developed residentially.
Right.
And so there is some recognition there that maybe you're trying to make sure that happens. When they adopted the Hamlet office and the Hamlet commercial zones, which are supposed to be designed to be residential-looking commercial buildings and sort of the transition area between residential and otherwise, they didn't apply that. And even in 2008, they didn't change it so that the pyramid would apply there, where you're right near residential or trying to look like residential. But so here, I think the point is that we're not impairing the solar access to Riverhead Building Supply or Quogue Sinclair in any means, but particular Riverhead Building Supply, because that's the pyramid encroachment on the west side. And I don't think we're in particular, since the planning board has reviewed the architecture and made us change and tweak things, and they've now found that the architecture to be acceptable, I think that there is a harmonious balance of the architectural character and the aesthetics they've sort of dealt with. So I think that the intent, we're meeting what the intent of the pyramid, and the board granting such relief would not be upsetting that intent, because I think it was always designed, as I think the chairman just noted, and I think you're all acknowledging, that it wasn't really intended for the residential zone, and thus if you are you're inclined that you can make a distinction here from what your track record is in residential zones as far as numbers or the amount of relief that you're granting.
Do the setbacks comply now?
Yes.
So it's
It's
just
only
pyramid
pyramid.
relief.
It's only the
That's
pyramid
relief.
relief and the reduced amount.
Right.
So.
Yeah, the first submission, I was not at all impressed by. But I feel like you've made improvements to the proposal. I'm glad that you met with the planning board and have direction from them, and I'm much more in favor of this proposal.
I agree.
I also agree.
Thank you.
Yep, and I'm good with it too. So you got 4 votes.
You're there.
Yep, all right. But before we do anything further, I want to ask, is there anyone from the public who is waiting to be heard this evening in connection with the application of Blessing Fields LLC for property located at 163 West Montauk Highway in Hampton Bays. Is there anyone who is waiting to be heard on Zoom in connection with the application of Blessing Fields LLC for property located at 163 West Montauk Highway in Hampton Bays? If you're waiting to be heard on Zoom, this will be the time to let us know by raising your hand.
Go ahead.
Okay. If not, Katie, is 9:15 okay for a decision on this one?
Yep.
Okay. All right, so I'm going to move that we close the application, except for written submissions. The deadline written submission is end of business on September 2nd, and we will have a decision ready at our September 15th meeting.
Second.
Mr. Daly?
Aye.
Ms. Burgess?
Aye.
Mr. Macedonio?
Aye.
Ms. Kern?
Aye.
Chair votes aye. Thank you so much.
Thank you.
Have a good rest of your night.
Thank you.
Thank you.
Okay, we're now up to number 8 on the agenda. 142 Town Point LLC, tax map 900-59-1-45, located at 142 Town Point Road.
Bruce Anderson, Suffolk Environmental Consulting, I was previously sworn in. The one thing the board definitely required of us was submission of the wetland permit. So I'll place that into the record. I can assure you, everything before you has already been approved. Conservation.
Yep, and I think we also got the referral report from Marty saying everything was consistent as well.
Okay, good.
And is that mainly what we were waiting for?
Well, it was one thing, and, you know, we had a neighbor that was to the
Susan. Pool equipment, I think, right?
west. No, it wasn't the pool, it was the air conditioning unit.
Oh, air conditioning, I just had to move, okay.
And so, what we decided to do, we thought at first we might put them up on the front lot line. We thought that was probably more in interest to the neighborhood. So we moved them to the other side of the property as shown on the submitted surveys to you. And just for point of reference, what happens then is that, you know, remember that the house that was there was about 3.5 feet from the property line, that there was a solid wood fence. So we put them there where, like 8 feet from the property line. We will maintain, we're gonna put in another solid wood fence, so it was just an accommodation we could make. And we also relocated the outdoor shower away from it, put it up adjacent to the pool. Again, just to show a little bit.
Are these all on the plans?
Yes, they're on the surveys.
Okay.
So all else remains the same.
Okay.
Can you just go through it again for me, Bruce? I just want to see it on the plans.
Okay.
Okay.
The
Oh, so here?
These are the AC units, they were over here.
Right.
This is the person that was concerned. There is a, this here is an outdoor shower.
Okay.
This was previously here.
Okay.
So we said, we provide a little more space here because we
That's right
could,
now.
and it was a nice thing to do.
Okay.
And that's,
Okay. And when you say additional fencing, you're going to put up a separate wood
Well, there
fence
is a
next?
fence
I know
there,
you
and
say
we're gonna-
proposed.
we're
You're going to
gonna-
put another
Yeah, it's
one?
going to be a solid wood fence to sort of protect the neighbors so that there shouldn't be any impact to that neighbor on the other side. So that's what we thought was a reasonable thing to do.
Yeah. Yeah.
Oh, I'm sorry.
We were talking about the fence and what you were going to do with the fence.
Yeah, the fence
on
will remain a solid wood fence. I know the architect is available on Zoom if you have any design-related questions.
Okay.
But hopefully we've made some accommodations for folks.
Okay. And at this point, the neighbor you had mentioned that was concerned, is the neighbor satisfied at this point?
I don't know.
Okay. Then the neighbor may or may not be waiting to be heard. Or speak to us, I should say.
And that was for the, not the pool equipment, the AC?
Air conditioning.
Yeah, it was the air conditioning.
Yeah, I just had notes about moving the equipment. addressed.
Yeah.
Stuff we talked about.
Okay. Okay, any other questions from members of the board?
No.
Well, is there anyone from the public who is here this evening in connection with the application of 142 Town Point LLC for property located at 142 Town Point Road in North Sea? Feel free to have a seat or go to the podium, whatever you prefer.
My name is Joseph. You got sworn in? or-
Yes, did I previously swear you in?
You did.
Yes, think so, yes.
Okay, then you're still
Yes.
sworn in. Did I previously swear you in? You did, okay, so if you can just state your names for the record.
Diane Deutschman.
Okay.
Joseph Mendola.
Okay.
Last time we were here, the plans that we had gotten were on a piece of paper this size, the same plans you got, but shrunk down, and we couldn't really read them. Any of the neighbors really couldn't read them. So we really didn't have a chance to do anything. Some of the questions that the neighbors had, I made copies from the neighbors.
Did you get regular sized plans?
No, well, he finally gave me only a copy of regular sized plan the last time we were here, so I had a chance to look at it and show them to some of the other neighbors.
Okay.
This is copies of the letter.
Yep.
I'll take them all, thank you.
And this is another letter from another neighbor.
Okay.
We feel that this project is just too big for the area. It's only a 50-foot wide lot. There is no other houses of this size on Tad Point. Originally, this was a summer cottage. Put a two-story house with a pool and a pool house, leaving the pool only 9 feet away from the next-door neighbor, not to mention the noise and the light that would, cause on the next-door neighbor, and the overhang of the house. The next-door neighbor is also some house that has no intentions of raising the house up, or, the houses get flooded there normally, and we clean them, and we go back to the next summer.
We don't want houses getting flooded.
Well, what I'm talking about is, if you know Tad Point, the wide open space. The other thing is the backyard in these houses. The ducks and the swans always come up in our backyards when there's storms. And when you put a deck right to the edge of the wetland, that can't happen anymore. The wash from the pool is less than 50 feet from a wetland. The backwash, chlorine. I don't think any of these things were really looked at. The 4 parking spots in the front of the house is only 60 feet wide. Put 4 cars in the front, it's gonna look like a parking lot on the roadside of the property.
So you want less parking spaces?
Maybe they could, instead of having all of that space and taken up by decks and pools in the property, they could have a driveway with a garage, and they park like everybody else. I mean, it's doable. I think on this piece of property, a 1-story house of similar square footage would be fine. We'd have the room for parking, we'd have the room for a deck, we'd have a land around the house, rather than developing the entire parcel to its max. And as far as profit, I mean, let's face it, it's probably gonna be a flip house. And the houses on Tad Point on the water make a lot of money, They don't need to put a McMansion there. There aren't any McMansions now on Tad Point.
Okay. All right. Anything else?
That's it.
Okay. Appreciate your comments. Ma'am, do you have anything to add?
Yes, I do.
Okay.
I am the neighbor to the east. I
Okay.
am directly affected by all of this.
Mhm.
They have taken this lot and they have absolutely put everything they can think of on it. In fact, the pool is 9 feet from my line, their pool. And they have a kitchen outside, and they have a pool house, and they have a pool, and I don't know, they have all kinds of things that make noise. And I'm the neighbor to the east. But they're right on top of me, and they have all this, stuff. I'm really, they're destroying the character of our little road, plus they're ruining me. I can tell you that right now.
This doesn't change the character of that area of Tad Point.
Absolutely.
Well, I have a question. I think I might have said this last time, perhaps. Could there be a conversation that can be had
I heard that.
about addressing your concerns? Is there anything more that can be done? Because you heard there were some modifications to the application. Is there more that can be done,
I feel that
other than us flat out denying the application?
Well, we still need a variance for the pyramid law, I believe, with a one-story house.
It's minimal relief than generally what's granted.
Excuse me?
It's minimal what they're asking for the pyramid relief.
Only because the two cottages that are on the property now were built on the property line, they had to move the property line over. Otherwise, that wouldn't be the case. When you put a house right at the edge of the property line, that's why they're going by, it's already is, the pyramid law.
So, but if it was
That's
a
only
one,
be-
so if
that-
it wasn't two-story, if it was one-story, that
I
would be
think it
better?
would look much better, it would fit the neighborhood. It wouldn't change the character so much with a great big two-story house.
My objection is the pool. Why would they need a pool on that little piece of property? They've got the whole bay in front of them. And the pool is very noisy, I can tell you that, because I live in the village too. And I have pools on all sides, but they're camouflaged, so to speak, and I don't.
This is a very sensitive flood area as well. When it rains,
Right, I
this
am in a
corner
flood
floods
area.
Okay.
very heavily.
Okay. Bruce, does this pool comply with setbacks?
It complies, exceeds the accessory setback.
9 feet exceeds the setback.
Yes.
But it's in a side yard.
But Bruce, the pool is 11 by 33 and 8 inches. Is there any way to reduce the size of the pool?
It's already exceeding the setback. So why, just because we don't like pools, I mean, it's not a big pool.
I'm just talking out
The
loud.
pool comes with a pool house and a deck.
Yeah.
It's not just a pool.
Well, they
There's
all
a pool
exceed the
house, a deck,
setbacks is the
there's the
point.
pool equipment, there's the waste basin for the pool. There's more than just the pool as far as
Okay.
the size.
Well, here's how it goes, okay, so you both understand. Okay, we have an application before us. If the applicant wanted to, the applicant could still further modify the application based on your comments, or the applicant can stick with the application as presented, and then, we decide what to do, considering what your comments are. But a conversation could be had
Yes,
to see if
feel
a
they'd
middle
like to
ground could be
speak to us,
reached rather
the
than,
architect would like to
it-
speak to us
yeah.
about, redesigning the project to something more acceptable to the area. I would love to speak to him.
Yeah. Did a conversation take place before?
No.
We can't force a conversation.
It just so
to take
happens, I
place.
believe the architect lives on the block. And I'd be very glad to speak to
But the
him.
question, people have a certain right to do on their property what
I
they want.
understand that.
They don't need.
I understand, but I read the things that make you guys give variances. And one of the things was about changing the character of the neighborhood.
One of the things.
That was one of the things. One of the other things was, can the people that bought the property receive a reasonable profit?
And that's not part of our analysis.
Isn't number 4?
Oh,
What is
no,
number-
no.
What's the number 4
No, no, no,
question?
no, no.
That's for the use variance, that's for a different standard.
That's a
We don't consider
completely
that.
different thing. No,
Oh,
no.
good.
No, no,
I'm
no, no,
glad
no,
you
no.
don't, but I thought that's what I read.
No, no,
But,
no, no.
basically, it's the character. I mean, if you drive down Tad Point Road, you'll see what I mean.
Yeah.
Picture what they want to put, and picture what's there.
The difficulty that we have of the things that you're both mentioning, and I'm listening to you, I'm hearing you that you're unhappy, okay? But the amount of pyramid relief, as Bob indicated, is a very small number in terms of pyramid relief. I mean, we routinely
They're not just
grant.
looking for a pyramid, though, in this. Are they?
But bear with me, okay? So the pyramid relief is a modest number, and the pool is conforming as to the setback. In other words, if the pool was required to be 20 feet from the property line, and it was being proposed at 10 feet, your concerns about noise about the pool will be something that would resonate with me quite a bit. But when the pool is at a conforming setback, the only reason the pool needs relief is because it's in a side yard instead of a rear yard, which often happens with these waterfront lots where the water side is the front yard, and what would normally be the front yard is the rear yard, so people end up having to kind of figure out what goes where and not necessarily be able to otherwise conform with the requirements of what goes in different yards. But the setback of the pool is conforming. If this were a rear yard, they wouldn't need relief for this pool.
What about being 9 feet from my property line?
It conforms.
It's right on top of me, this pool.
That conforms. You're not seeking relief on that.
That conforms? You can have a
What the setback?
9 feet from your property line?
Yes.
What is the setback for pools? 8 feet, okay.
But can you have a swimming pool in the side yard?
Well, you can't, that's why they're
And
asking
that's
for that relief.
And so that's why I'm raising the swimming pool.
Yeah, but as I explained to you, that Well,
It's
I
also
don't want to go over it all again,
It's
but
also in relation to where the house is. If the house was over more, then it wouldn't be in the side yard. It's all,
Right,
it's all the
right.
placement of all of the structures. But if the
Right.
house was to move over more, there'd be a bigger pyramid
Right,
approach.
and this is proposed as opposed to like an as-built situation
No, I
where
agree.
most of it's already
you
there.
have two houses.
Yeah,
Have a
yeah.
non-conforming use of the property.
Yeah.
But I think the
Tad point
point
was-
about the pyramid relief, and the existing pyramid relief is true. The houses are right up on the property line, and that's why it had a pyramid relief of what it did.
Right.
So,
No,
well,
Yes.
Pre-existing pyramid law.
okay,
Those houses
okay,
pre-existing
okay.
pyramid.
Yeah, they're
But
very
they,
old, so I'm
it
sure
had
they
to
did.
pierce
But
the pyramid law because of the on the property line.
But let me mention something about the pyramid law and houses that are by water, okay? When you go to do a major addition on your property, you're gonna have to raise your house. You're gonna have
That's
to raise it.
fine. I would love to see them put a house on that property,
But
raised to the flood limit.
No, but I-
One story, they don't have to put a great big monster house on a small lot, it's a 50, 60.
Okay.
60 because of the notch out,
No, I-
60-foot wide lot.
I understand you want it to be one story, not two story, but you,
But I just-
but
if they
flooding,
want-
flooding is a
I
significant
just think
concern.
if they go 2 stories straight up, it'll just look funny, you know? A 1-story house would look fine. It would
But
fit the
as
area.
the houses get
The
renovated,
character of the neighborhood will definitely
They go up.
change by putting this house there, and there's no getting away from it. And if that's, you know, what I thought you people were here for.
no.
That's
no.
one of the.
I know that's
Yeah,
one,
yeah.
but
Right,
I'm
but
pretty sure
something
that's
we
a pretty
have to
main
absolutely
one.
take into consideration, and
I
you
know,
know.
and I really, and I appreciate it. I hope you
Yeah.
do take it into consideration.
No.
And what my neighbors wrote, they take it into
Yeah,
consideration.
absolutely.
That's
Yeah,
all.
No,
yeah.
And that's
absolutely,
all
we
I
will.
want.
But I
I
want.
appreciate you here, listening to me.
We will.
No,
and
no problem.
understanding the way
But I just want you to understand, we
I do.
do not want houses to flood. We want
I
houses
understand that,
to
and I
be
don't want
protected
houses
from
to flood
flooding.
either. I
So
live- I
that
live
means,
there.
I
live
understand.
there.
So that
I'm one of
that
the very
means.
few people that live there full-time.
So that means.
Actually, one of the 3.
Okay, excuse me. Okay, that means sometimes we have to consider pyramid relief when people are trying to protect their houses from flooding. Okay? I understand this is proposed, and so you can say, no, I want it to be 1 story, not 2 stories, and they won't need pyramid relief at all. I appreciate that, but we don't want people's houses flooding. I want to make that clear. And the character of your neighborhood is going to change. It's going to change as people raise their houses to protect them from flooding. That's what's going to happen, because
But it
that's.
doesn't have to change to make it ugly. It doesn't have to change where there's no curb appeal.
that's an opinion.
No, I'm
It's an
sorry,
opinion.
you know, if board
It's
would
a
drive
subjective
down Tad Point Road and look at some of the failures of the board as far as giving variances on a couple of the houses on Tad Point, it's true. There's houses on Tad Point Road that are 6 feet from the road without a shrub in front of it because they were granted a variance.
Feel free to submit copies of any determinations of our board that you would like. Feel free to have us
I'm
take
not saying
a look at
you,
that.
but
Feel free. Okay, you're entitled to do that.
Ones that really disturb you, you're entitled to give that feedback.
Feel free. The public hearing is going to be left open for written comments.
No, it's gonna be held
Feel free
open.
to submit
I do
anything you would
understand
like.
Can't tear something down.
It's gonna be held open for written submission, so you can submit anything.
Yeah, anything you want. Okay.
But just for the record for the board, if they had proposed to build this new house in either one of these pre-existing non-conforming locations, all of those accessory structures would likely conform. Because they're so pushed, the houses are so far pushed over that they would all be right in the middle of the lot. so.
Right.
Moving the house towards the center,
You know,
which
we're
is the
finding.
pyramid, and makes it more conforming.
We did had an application withdraw that over a long period of time, it was clear we were not going to approve it. And that's going to get built in a way that the people in that neighborhood further east from you are still going to be livid over it, because it's just the pattern that's happening today, the way development is happening. Even if they had no relief, you would still be probably out of your minds when something like this gets done.
And that's,
But you know,
and that's a
they're
conversation
pushing
for the
out
town
a-
board.
And I'm
They're
gonna be
pushing-
out of my mind.
They're pushing our children out.
Yeah.
Don't you see that? They're pushing our kids out of
Yeah,
town.
yeah. But I
You
want
know,
you.
I'm born and raised here.
Yeah.
The only reason why I live on Tad Point, when I was younger, I couldn't afford to buy a house in the village somewhere. I bought a little cottage out on Tad Point and fixed it up over the years. And I lived there. These little places that people rent sometimes in the winter to live, they're going. You're making these big mansions out of all of them by.
We-
a lot.
we-
No, I'm sorry, I don't mean to say that. And I really, I apologize for using we.
The market is.
The market, the way it is just pushing everybody out.
But the town also is very active in getting affordable housing, too.
Okay, we're off
But we
topic.
have.
We
but
are.
We have.
We need to
Way off
stick to this
Right,
application.
I know. I mean, we're getting off.
Okay.
We hear.
I know you
we
understand
hear-
what I'm
Wait, I
saying.
wanna
And the
Yeah.
letters that you're sending.
And I appreciate you
We're gonna
listening to
take
us.
all of
So
that.
hopefully we can work out something. And if-
Well, I wish there could be a
love
conversation
to
that could be
speak.
had, but it doesn't seem like
All right,
there is
maybe we could-
that's taking place.
Do you
He can
people
convince me
ever,
or I can convince him.
do you people ever go and look at these projects?
did.
We certainly do.
We do.
I know you've been
I've
there.
been, and
We
it's
do.
a lovely, charming
Well,
neighborhood. and
hopefully
it
we
is-
could try to
and
keep
I
it as
know
long
you
as we
will.
can.
I know,
know
but I have.
someday I
you know,
won't.
Someday, yeah,
But-
you know, unfortunately, I still would like to see if, you could have a conversation with Bruce and,
I would,
and, and it may be nothing comes out of it, but
like I
I
said, I
would
have
feel
nothing
better
against
if
that. I
you
would
at
love
least
to.
had the conversation.
Really.
Bruce, are you willing to
All the
have
neighbors,
your
all the
client-
neighbors just want,
We've
we want something that's appealing to the
already.
neighborhood. That's all. You know-
already been accommodated.
We're
We're not doing a
accommodating-
one-story house, no.
All right,
My
And we do want to
place-
center the house in the lot, because that's where it makes sense.
yeah, it does, it makes sense.
You know, it's some of the other things.
My
Bruce.
place is gonna
The
be
deck
just
on the back of the
devastating.
house on the wetland.
It's all open.
That's a little excessive, that size.
We got a
of the
lot of
deck.
people talking at the same time. I think you have enough testimony.
I think we
so
do.
too.
I think we do.
Thank
All
you.
right, I appreciate it. And
Okay.
Please, I'd love to speak.
And if any of you ever get a chance to go down Town Point Road, please come down. I used to be on the ARB in the village for 9 years, when the pyramid law we were discussing.
Wow.
And we would go out and look at these things that were
Look at Tide
so,
Point, Conscious Point, all of North Sea Harbor, and Marina.
Do you have beach plums down
no, we do
Oh,
not.
okay, well,
We got swans,
there? Okay.
lots of swans,
Okay.
but no.
All right, thank you
Okay.
for your, thank you for your testimony.
Thank you for your comments.
Thank
We do
you.
appreciate it.
Thank you.
So what happens now?
We have to render a decision, but it's not happening tonight, so we're going to be putting it on for decision. Momentarily, we'll let you know when.
Did you get the letter from my other neighbor?
It
No,
has
let
to
me
go to
take
the-
that, I didn't get that copy,
I
thank
have to
you.
go to Casey.
Just didn't get enough.
Yeah.
Second copy.
Okay.
Okay,
Thank
all right, okay. There isn't anyone here in the audience. Is there anyone from the public who is waiting to be heard on Zoom in connection with the application of 142 Town Point LLC? This is for property located at 142 Town Point Road in North Sea. If you are waiting to be heard on Zoom, this would be the time to let us know by raising your hand. Okay, if not, Susan, it is yours.
Okay, we're going to close the public hearing.
Thank you.
Thank you.
Leave it open for written decisions due on September 2nd with a decision on September 15th.
Second.
Ms. Kern.
Aye.
Mr. Daly.
Aye.
Ms. Burtis.
Aye.
Mr. Macedonio.
Aye.
Chair votes aye. Thank you so much. Have a good rest of your
Okay,
night.
have a good night, thank
If you can have a conversation with these folks, we would encourage it.
Thanks, Bruce.
I understand. Yeah, I get it, but
It's not easy.
I appreciate that.
At least we'll have a conversation.
And
I actually did.
and if anything happens, let us know. Okay.
Yeah.
Yeah, okay. Greatly appreciate it.
That wasn't exactly accurate.
All right. Okay,
All right,
Registration.
now we are on decisions.
we are, and I have a few.
I have one.
You want to do yours first?
Okay, let me see.
Okay.
There we go.
Okay, I have a decision in the matter of the application of Madeline Feldman and David Alpert at 24 White Birch Trail, Suffolk County Tax Map 900-290-3-64. And this is a non-conforming lot of 16,000 square feet in an R20 district, which requires 20,000 square feet. It has a 160-foot road frontage and a depth of only 100 feet. The property abuts 2 roads. Given the depth of the property and the setback requirements of 50 feet, there's no ability to add accessory structures. Subsequent to, and this was for a pool. This is for a detached garage, a proposed swimming pool, and a covered porch originally. Subsequent to the first public hearing, a request came in to change the variance request
from a covered proposed porch to an enclosed porch, well, I can't speak tonight, enclosed proposed porch. The size and location of the revised request are the same as presented at the hearing. At the meeting on August 4th, the ZBA voted to reopen the application, accept the written submissions, and close it for decision at our meeting tonight. We find in this instance applicants established that it's entitled to the requested variance relief, finds the benefit to the applicants of granting the variances outweighs detriment to the health, safety, and welfare of the neighborhood, and that it meets the 5-part test under town code and state town law. Therefore, the board grants relief from the following provisions of town code. 1, for the proposed detached garage. 1, section 330-11 residential districts, tables of dimensional regulations, for an accessory distance from the street front yard setback of 32.5 feet, where 50 feet is required from the easterly property line, which is White Birch Trail, and 2, for an accessory distance from the street front yard setback of 32.5 feet, where 50 feet is required from the westerly property line, Shinnecock Avenue, and 3, section 330-76D, placement of accessory building structures and uses in all districts, and section 330-83C yards, to allow the proposed garage to be located within the required minimum side yard for the principal building. 2, for the proposed swimming pool, section 330-11, for an accessory distance from the street front yard setback of 34.1 feet, where 50 feet is required from the easterly property line, and for an accessory distance from the street front yard setback of 34 feet, where 50 feet is required from the westerly property line. And 3, for a proposed enclosed porch, section 330-11, for a principal rear yard setback of 32 feet, where 60 feet is required. All is shown on the survey prepared by Scalise Land Surveying, last revised on July 27, 2022, and the plans prepared by Salvador Ionone, R.A., dated July 27, 2022. Grant of the foregoing relief is subject to such other conditions and permits as applicants have already acquired or may otherwise have to acquire for final approval of the subject premises.
Do we have a second?
Second.
Ms. Kern?
Aye.
Mr. Macedonio?
Aye.
Ms. Burgess?
Aye.
Mr. Daly?
Aye.
Chair votes aye. I have 4. First one is the decision on the application of 87 Foster Ave LLC. This is for property located at Suffolk County Tax Map number 900-374-26. This application is for property located at 87 Foster Avenue, Hampton Bays. The applicant here requests variances to construct a pool on a lot that is burdened by 3 front yards in an RWB zoning district. This application passes the standards set forth in New York State Town Law and the Town Code. Therefore, this board grants applicant relief from the following provisions of the Town Code for a proposed swimming pool. 1, Town Code 330-34, Business Districts Table of Dimensional Regulations, accessory structure setbacks, for an accessory distance from street setback front yard of 32 feet from Lighthouse Road, north property line, where 60 feet is required, and an accessory distance from street setback of 50 feet from Foster Avenue, east property line, where 60 feet is required. And Town Code 330-76D, placement of accessory buildings and uses in all districts, and Town Code 330-83C, yards, to allow the proposed swimming pool to be located within the required front yard for the principal building. This relief is for the swimming pool as shown on the site plan prepared by Michelle A. Wagner, R.A., dated April 29, 2022, and is conditioned upon the following. 1, legalizing or removing the frame gazebo and all fences prior to the issuance of a certificate for the swimming pool. 2, the installation of a pool dry well, and upon elevation of the pool, inclusive of foundation, at least 2 feet above groundwater, and a low chlorine or saltwater treatment system. The granting of this relief is also subject to such other conditions and permits as applicant has already acquired or may otherwise have to acquire for final approval of the subject premises.
Second.
Mr. Daly?
Aye.
Ms. Kern?
Aye.
Mr. Macedonio?
Aye.
Ms. Burgess?
Aye.
Chair votes aye. Next, I have an amended decision in the application of Beach Properties, Inc. This is for property located at Suffolk County Tax Map number 900-384-354. This application is for property located at 25 Shinnecock Road, East Quogue. Applicant seeks to amend ZBA decision number D012929 dated September 15, 2011 in connection with a proposed 2-story dwelling. Here, the design of the dwelling was modified, thereby reducing the previously proposed pyramid encroachment and increasing the principal rear yard setback. This amendment passes the standards set forth in New York State Town Law and the Town Code. Therefore, ZBA decision number D012929 is hereby modified to grant the following. 1. Relief from Town Code 33084D, pyramid height, for proposed encroachment in the amount of 364.2 cubic feet, 222.6 cubic feet on the north side, and 141.6 cubic feet on the south side. And 2, Town Code 33011, Residential Districts Table of Dimensional Regulations, for a principal rear yard setback of 24.7 feet, where 30 feet is required, for a proposed two-story dwelling, as shown on the plans prepared by architect Todd O'Connell, dated January 15, 2011, and the pyramid sketch dated June 27, 2022. January 15, 2021, and the pyramid sketch dated June 27, 2022, and the survey prepared by Floyd Carrington of Rayner, Marks, and Carrington, last revised July 5, 2022. Granted, the foregoing relief is subject to such other conditions and permits as applicant has already acquired or may otherwise have to acquire for final approval of the subject premises.
Second.
Mr. Macedonio?
Aye.
Mr. Daly?
Aye.
Ms. Kern?
Aye.
Ms. Burgess?
Aye.
Chair votes aye. I next have a determination in the matter of the application of Cloverleaf Realty, Inc. for property located at Suffolk County Tax Map Number 900-133-21. This application is for property located at 2 Montauk Highway, Watermill. The applicant here requests variances for 2 wall signs to face parking lots where wall signs are only allowed to face public streets. This board finds that the application passes the standards set forth in New York State Town Law and the Town Code. Therefore, this board grants relief from Town Code 330-205A1, General Provisions / Wall Signs, to allow a 25.8 square foot sign to be located on the south wall of the building facing the south parking lot, where only a wall sign facing a public street frontage for each business operating within the building containing such wall is allowed, and to allow a 44.6 square foot sign to be located on the east wall of the building facing the east parking lot, where only a wall sign facing a public street frontage for each business operating within the building containing such wall is allowed, as shown on the plans prepared by BAM Creative, last revised August 16, 2022. The grant of these variances is subject to such conditions to the conditions of such other permits as the applicant has heretofore acquired or may otherwise be necessary.
Second.
Ms. Kern?
Aye.
Ms. Burgess?
Aye.
Mr. Macedonio?
Aye.
Mr. Daly?
No.
Chair votes aye. Next, I have a determination on the application of 40 Ocean View Drive LLC for property located at Suffolk County Tax Map Number 900-271-144. This application is for property located at 40 Ocean View Drive, Shinnecock Hills. The applicant requests a variance for a pyramid encroachment for a proposed 2-story dwelling, initially proposed at 8,788 cubic feet, and then modified twice to reduce the encroachment and redesign the house. This board finds that the application passes the standards set forth in New York State Town Law and the Town Code. Therefore, this board grants relief from Town Code 330-84D, pyramid height, for a total pyramid encroachment in the amount of 1,342 cubic feet, 813 cubic feet on the east side of the property, and 529 cubic feet on the west side of the property, for a proposed 2-story dwelling. These variances are granted for structures as shown on the survey prepared by Nathan Taft Corwin III, surveyor, last dated August 9, 2022, and the plans prepared by Brian Glasser, architect, last revised June 24, 2022. The grant of the foregoing relief is subject to such other conditions and permits as applicant has already acquired or may otherwise have to acquire for final approval of the subject premises.
Second.
Mr. Macedonio?
Aye.
Ms. Kern?
Aye.
Mr. Daly?
Aye.
Ms. Burgess?
Aye.
Chair votes aye. Any more decisions? No. Motion to close?
Motion to close.
Motion to.
Second.
Second. All in favor?
Aye.
It was quiet without Keith tonight.
We are closed. Thank you, Katie. Thank you, Candace. Thank you, Charlie.